While medical marijuana has been legal in the state of Florida since 2017, the Florida Supreme Court has finally ruled that recreational marijuana can be on the ballot in the November election. Now, what impact might this have on the medical marijuana industry as well? So let's talk about it. Hey everybody, it's Dr. David. Hope you're having a great day. So, as many of you know, I am a board certified pediatrician medical physician. I am also a medical marijuana advocate since day one when the bills were being put forth in the first place, and the constitutional amendments, etc., allowing for medical cannabis. And I've been even further than that, I've been using medicinal herbs in my practice. I'm not talking about marijuana since 1996. It's as a holistic pediatrician. It's something that I learned a lot about. So when the medical marijuana laws came into place, I certainly had a head start on everybody else because I already knew how to figure out dosing regimens for people on an individual basis when there wasn't a lot of research available. Now, I've also been told that I'm the most experienced medical marijuana physician as a pediatrician in the state, that I've certified more children. I've also certified many adults, and I also do provide medication management for patients. But I also, as part of my Dr. David MD, my educational consulting business, I do also provide medical recommendations and suggestions as to how it might help individuals who are not patients of mine, but maybe outside of the state, who want education to see, well, what would be a typical dosing regimen of what kind of products based upon a person's symptoms, although I don't actually prescribe it for them because, of course, they're not my patient. Okay, so now the big news is that the Florida Supreme Court has ruled that recreational marijuana can be on the ballot in the November elections coming up, and it would be as a constitutional amendment. Now, the Division of Elections determined that, first of all, that the initiative qualified for the ballot back in June of 2023 in terms of meeting the minimum number of signatures. The initiative was actually assigned ballot the name Amendment 3 on January 26th of 2024. And the sponsors of the amendment has now submitted over 1,033,000 signatures, well beyond what was needed in order to get it on the ballot in the first place. Now, let me explain to you specifically what the wording is. And as you may know, the wording of constitutional amendments in Florida can only be about one issue and one change. The good thing about that is that it makes it much more easy for people to understand. So the wording is as follows. It allows adults 21 years or older to possess, purchase, or use marijuana products and marijuana accessories for non-medical personal consumption by smoking, ingesting, or otherwise. It does not specifically say that it allows for home grow, however. It allows for medical marijuana treatment centers, which are the state-approved medical cannabis dispensaries, and other state-licensed entities, although it doesn't say what, to the ability to acquire, cultivate, process, manufacture, sell, and distribute such products and accessories. It does not change or immune from violation for the federal law, and there's always been that difference between federal law and state law, that the federal government has declined prosecuting anybody who is violating the federal laws if it's legal in their states. And of course, we hopefully will see a rescheduling or descheduling of cannabis at the FDA level, so that it is no longer the level of illegality that it currently is. Now, in terms of part of this, and it's also important to know 60% is needed for this, as well as any other constitutional amendment to pass. Now, the findings of the Florida Financial Impact estimating conference, so they kind of figure out what all the finances are involved, and they expect that by the time that the market is fully operational, that between that the sale of non-medical marijuana, so recreational, would generate at least $195 million in state and local taxes per year. Now, also under the current law, because of the way the wording is, the existing statutory framework for medical cannabis will be repealed 6 months after the effective date of the new amendment, if it were to pass. And so, of course, that will impact the way that the amendment will be implemented itself, and that's up to the legislation. There will be a new regulatory structure for both medical and recreational use. That will be needed. And it, of course, says that the design of that will not be known until the legislation acts. Okay. So, of course, how the legislation puts it all together, it can make it a very open system, or it can be quite limiting. So we're going to really have to see and advocate to make sure that they do the right thing. Now, the effect on medical cannabis. So really, it depends on what the legislation is going to craft, and I really, really hope they don't screw this up. I think that the Florida system is working really well right now. I think that the product availability, the variety, etc., it's really quite impressive. It's better than I ever thought it would be, and I really hope they don't mess this up. Okay, now many other states. And always medical happens before recreational. Most other states, when they brought the recreational into legality, they made it that was heavily taxed, but not medical cannabis. And of course, that is going to make a big difference as to whether people stay in the medical program. If it's financially beneficial to a patient to stay because they're not paying a hefty tax, then the medical system as a whole will stay intact and will flourish. If there's no difference there, then of course there goes the medical use, because most people would probably move over to recreational if they don't have to have a doctor's authorization and get a card. Now, of course, how much will the state lower the cost of getting a card? Will the state decrease how often, maybe going from 7 months to 1 or 2 years instead? Then, of course, those things will play as well. But also, from a pediatric perspective, no matter what happens with this constitutional amendment ballot initiative, pediatrics obviously will not be changed because the law will still be intact, because no matter what happens, under age 21 will still not be allowed to use medical. So I guess even the 18 to 21s would stay in the medical system as well until they turn 21 if the opportunity was better for them to do that. So overall, that's kind of how that affects. Now, why is it that I do support this measure? First of all, because it's at age 21. By age 21, the brains are developed. Okay, so there is a concern, obviously, with use, and especially recreational and uncontrolled use among children, adolescents, what that could be doing to developing brains. Number two, let's be honest. Alcohol and tobacco are both legal and they're not going anywhere. And no person who has any knowledge about this whatsoever could possibly say that marijuana is more dangerous as a whole to the human body, to society, than alcohol or tobacco is. Okay, so, but also, on my own medical advice here, if recreational does come forth, I still strongly believe nobody should be smoking marijuana. Nobody should be burning particles into their lungs, especially because there are other ways of getting the benefits, such as through dry herb vaporization, as well as obviously some of the more advanced, less solvent containing, or processed, not solvent containing, that hopefully they remove it, but solvent processed vape oils, and of course oral products as well that don't involve any swallowing whatsoever. So there's my take. Hope that you learn more about this, and of course, if vote how you feel is the right way to vote. Have a good day.